Bye. Oh yeah, wait, there's a fee.
Diddy.
Oh shit. I'm faster.
o'clock or class is there, right? I'm going to show them the roll call and ask them what time is this court my place.
Correspondence.
That was bad.
Do something.
Wearing it if I don't have to. You know? It's not probably not the best, right?
If you live in India and grow tails, you'll be a god. Now look at this.
We got Jerika. Jerika's our correspondent in the Bill Court. Going on vacation tomorrow.
Florida for 5 days and Costa Rica. Ready? Text, right? 314?
Yeah. I'm up. If they want to see me, do they need to be rolling on it, or?
guys that we shot, and we're like, I don't know.
Yeah. Gray hair.
Yeah, I mean,
Maybe that one.
I don't know what they look like.
I thought he got a different one. Oh, his old ones look like.
They got a car out there. That's to a car, I think. I think they were getting to a car out of the lot. That's what we said.
Oh, okay. Appreciate it. Thank you.
No, who said I was even walking over there? So what? I'm not walking over there.
That was it?
Just one of them.
Oh, sorry, Chief.
Everybody's got space. It's all good.
What do you think? One more car or what?
What?
One more car? That was it.
So I don't think there's another car.
What happened?
It's already two, so
That was it.
I think that's it.
Okay. Thank you.
That's lunch.
Yeah, that's it.
Setups?
Another thing.
Hey Ben, how you doing? It's Ari. I'm outside the Diddy trial. Put the video on live view up and running. I don't have names. Our table works. When they pay us the big bucks. You see it now? Yeah, I'm off to the right.
Alright, maybe, yeah, there it is. Yeah, that's the family committed. That's what we got. Lawyer, nobody got the lawyer.
The message I got was the Law&Crime.
We're alone
So
in
that
that.
nothing happening with just the
Yeah.
So we're also
It's the same thing as the last time we just do
Get the shot?
You need to come through?
Yeah, my tripod's right behind you, fellas.
All right, let's go see the. I'm gonna go where you are.
Thanks, man. Thank you, gentlemen.
That's fine.
thought. I think we got but they'll do it. I sent a picture to Adam. You guys,
Officer, you want to speak in front of that for us for 1 second? Thank you, officer. Stand by and go for it.
What do you want me to say?
Just not the camera.
My Friday is great. It's almost over. Thank you.
Okay, thank you.
Kelsey already told me.
Good afternoon, everybody, and thanks for tuning into this special live coverage here on Law and Crime. I'm Jesse Weber. So, we are right now live in this much anticipated hearing for fallen music mogul Sean Diddy Combs in his criminal case. Now, there is apparently a lot going to be happening today. So first of all, Combs is expected to appear in court, and he has already appeared, I should tell you, for an arraignment on the second superseding indictment in the government's case. And remember, this was filed last week. He is facing charges of racketeering conspiracy, sex trafficking, transportation to engage in prostitution. He hasn't been hit with additional charges. There's no new defendants, but really he's pled not guilty already to all of these charges originally. But really this new indictment focuses on allegations that he engaged in forced labor as part of the underlying racketeering criminal enterprise charge. We'll talk more about that. Now, it is possible that lawyers for Combs will also ask Judge Arun Subramanian to dismiss part of his criminal indictment, claiming that one of the charges that he's being faced and that that's being used against him is racist, that it was rooted in racism, that the prosecutors have engaged in selective prosecution, and this is the prostitution charge that he wants tossed. Then, we also expect to hear arguments regarding jury selection. Both the government and the defense have proposed vastly different schedules ahead of Combs' May 5th trial date, along with jury selection being anticipating arguments over how that's going to work and whether or not there should be a written jury questionnaire and what questions will be on that questionnaire. But also, one other highly anticipated topic surrounds CNN and the widely circulated hotel footage that was released last year, allegedly showing Combs beating up his ex-girlfriend, Cassandra Ventura, who we believe is victim one in this case, and this happened back in 2016. And the defense is alleging that CNN purchased the only known copy of this surveillance footage, altered it, and then destroyed the original footage. And they plan to file a motion to exclude that altered footage from coming into trial. Now, we are going to be providing you live updates from what is happening in that courtroom. There is no cameras allowed in the courtroom, but we're going to provide you live updates. I already have live updates for you right now. And we're also going to be taking your questions. So if you have questions about this case, about what is happening in real time in that courtroom, submit them on YouTube. We will answer them here live on air for you. Also, I want to let you know that our very own Elizabeth Milner is inside that courthouse right now. She's going to be coming out later, give us a live look about what she saw, what she heard, and I'm going to bring on my guest in a second, but I have to give you some live updates. So first of all, it's being reported that Sean Combs has been led into that courtroom by U.S. Marshals. He is wearing that tan uniform from the Metropolitan Detention Center in the jail. It's basically the same uniform that we have seen him in the past, or at least we've seen from courtroom sketches. His hair is reported to be silver gray, so perhaps he is getting a bit older in jail. We'll talk a little bit more about that. An update, the judge has said, "Good afternoon, Mr. Combs." Good afternoon is a response from Mr. Combs. "Have you seen the superseding indictment," which we just talked about? Combs replies, "Yes." The judge asks, "Do you want me to read it out?" Combs replies, "I'm fine." And then the judge says, "Do you waive the public reading?" Combs responds, "I do." We have another update. The judge says, "I propose we administer jury questionnaires on April 28th, 29th, maybe 30th. We'll come back for voir dire, jury selection on May 5th, with an eye of starting trial May 12th as the defense suggested." And then asking Assistant United States Attorney Steiner, what do you think about that? To which Mitzi Steiner replies, "That's helpful. Our focus is witness availability." A lot to talk about here, so I want to bring on my guest to focus a little bit more about this. I'm joined right now by criminal defense attorney and former prosecutor Safa Robinson Ferrer, and also criminal defense attorney Bradford Cohen. It's great to have you both here. Bradford, I'll start with you. Waiving of the reading of the indictment, not surprising here, but also talk to me about what you make of why prosecutors actually filed this superseding indictment. Because when you read it, it's literally the inclusion of one additional paragraph.
Yeah, I think it's in my opinion, it's a mistake. They should have stuck with the original indictment. The superseding indictment about, that he had employees that he didn't pay, and the paragraph surrounding that I guess they're going to throw in like an element there for that paragraph. I don't think it was useful. I don't think it was something that was necessary. And I think it cheapens the rest of the case, in my opinion, as to what they're actually going for and actually what they're trying to prove. And it's very difficult in these type of cases. And I'm not saying that it's easy on either side, but it's very difficult on these type of cases to have a jury to say, hey, these aren't two consenting adults. These aren't individuals that have been paid for whatever they're doing. This isn't what they're making it out to be as a sex trafficking case. In your mind, when someone says sex trafficking, it's aghast, right? Everyone's like, oh my God, what are the facts from this sex trafficking? What could have been be? And then all of a sudden you hear, well, it was that his girlfriends and himself were engaging in these prostitutes that were come over to their house, and they were paid between $5,000 and $10,000 for the whatever happened. And that's the sex trafficking. That's kind of a hump that they have to overcome. Although legally speaking, you can make the argument. It's still in people's minds. How is this sex trafficking? And like I said, it is not that the legal elements aren't going to be met, because I think they are. And in terms of what the evidence is, it seems like they've reached that point.
Right.
What my argument is a jury is going to have a tough time wrestling with charging someone criminally for someone calling a prostitute to come over and make $10,000.
Let me add a little bit more context to all this. So this is going to answer some of the questions we're already getting in from YouTube. So one of the questions is from Fabio Barney Benton. What is a superseding indictment? It is basically almost an amended indictment. There is something new here. There's additional allegations that have been put forward. Sometimes you'll see additional defendants named in an indictment or additional charges. That's not what we have here. Because the second question we have is from Ann F. What, if anything, is new in this indictment? Well, this is what we're talking about. This one new paragraph. Combs, along with members and associates of the enterprise, also maintain control over certain employees of the Combs business, whom he forced to work long hours with little sleep through use of, among other things, physical force, psychological harm, financial harm, and reputational harm, and or threats of the same. In doing so, Combs, assisted by members and associates of the enterprise, caused these employees to believe they would be harmed, including by losing their jobs if they did not comply with his demands. With respect to one employee, Combs used physical force, psychological harm, financial harm, and reputational harm, and or threats of the same to cause the employee to engage in sex acts with Combs. We do not know who these employees are. We do not know who that specific employee is. But again, this forced labor allegation helps support the underlying racketeering conspiracy criminal enterprise charge. And as we heard from a response from the defense, when this was filed, it seems they may be calling people who work with Sean Combs to negate that. Now, Safa, I have a question for you as we get a little bit more into this. This is an update again from court. Combs' lawyer Mark Agnifilo said, "We'd like a sequestered voir dire." The judge says, "We'll do that. Next is defense discovery. You'd like to do something like in the Eisenberg case." Before we even get to the defense discovery, it seems right now, Safa, the defense is winning a lot of this. So now they've got their proposed schedule where you're not going to see the actual maybe opening statements till May 12th. Now they're going to have a sequestered voir dire. Is this good? Is this a good thing?
I think this is a great thing for the defense. One of the things that's important is that they adequately prepare for their trial, especially heading into that voir dire period. A lot of times cases are won or lost by the jury that you pick. And it's so important for attorneys on both sides to be able to, find out who these potential jurors are, do their own investigations into those potential jurors to ensure that they're appropriately and properly picking the right jurors. I think for time's sake, this is also really good because it allows the case to push further along. I think that this trial is going to take about 2 months, and we want to make sure that there's no undue delay. And so I think that moving forward in the voir dire process in this way is most efficient. I think it's great for the defense.
We have a question from Haija Del Alcimio. This is from me. Why did you say allegedly? The whole world saw with their own eyeballs him beating Sweet Cassie. Look, the reason I have to say allegedly is because he hasn't been convicted of anything with respect to that video. He hasn't been found liable with respect to anything in that video. I think we can all make the argument it's pretty clear what we see, but just as a matter of law, I have to say that. Now, I want to move on to something else. Bradford, now it's moved on, this is a live update, moved on to the discussion of the CNN video, which we just talked about. So the judge asked AUSA Steiner, the prosecutor in this case, on the CNN video, is there an issue with it? Are you going to use it? Mr. Agnifilo says there is a motion incoming. Again, the idea that they want to have it excluded because they said that CNN altered it. And then AUSA Steiner replies, we want their Rule 17 subpoena returns to understand what they have. Our view is that the video is direct evidence. And just let me add one more update from court. The judge says, we do not have the original security video. The prosecutor responds, we have the CNN and a recording of the original footage. The judge responds, will you confer with the defense to agree on which video will be used at trial? You're not trying to mislead one, are you? And to which the prosecutor says, of course not. Now, Combs' lawyer, Mark Agnifilo, responds, a source gave CNN hotel footage. CNN ran that footage through a free editing software. Our expert says that changed the nature of the action, making it up to double time quicker. They took things out of sequence, took out the timestamps. Now, Bradford, I can understand why the defense is focusing so much on this key piece of evidence, because it is a key piece of evidence. It is really bad. What are we supposed to take away from this, and whether or not it will be included or excluded from trial?
So if the allegations are true, this type of stuff gets me fired up, right? It's CNN buys a video and then takes that video, knowing that it's probably going to be evidence either in a civil or criminal trial. They manipulate the video in terms of time. And this is, I'm just relying on what the defense is saying. I don't know this. But if it's true, they manipulate the video as to sequence and time, take the timestamp off. It's probably shortened from the whole video that they received, because it could have been an hour-long video, but we only have those 4 or 5 minutes of what we see. Now, if the original video is not available and the government is saying, well, Judge, we have the quote-unquote original video, they could be talking about the original video that CNN manipulated, not the original video that they got from the hotel. So it's like a word puzzle here. And it always comes down to, whenever you deal with the government, it seems like you have to nail them down on these terms and say, do you mean you have the original video that they got from the hotel?
Bradford, let me just follow that up with you, because we have another update, so I'm curious what you think about this. Mark Agnifilo, again, Sean Combs' lawyer, said, we say the video is deceptive. We'll bring that before your honor. To which the judge responded, Bradford, a possible solution would be to slow it down or put it in the right sequence. You may want to block it even if it's totally accurate. Try to come to a compromise. What does that mean?
It means that he's leaning towards letting it in. That's my first impression. But that being said, you have to take a look at where the video came from, the chain of custody, how it was manipulated, how it happened to fall into their hands. Why does CNN get a free pass here for destroying evidence that they knew would possibly be used in a civil or criminal action? And from what I've read, the criminal action was already started when CNN destroyed this original video. Why is there no investigation about CNN for destroying a key piece of evidence and doing whatever they wanted with it, slowing it up, speeding it down, whatever they were going to do to it? It's not what should be turned over to the defense.
CNN denied the allegations. In a statement to USA Today, they said CNN never altered the video, did not destroy the original copy of the footage, which was retained by the source. CNN aired the story about the video several months before Combs was arrested. I'll tell you what, Bradford, we'll talk a little bit more about that. I do want to move on to another question, Safa, that we just got. This is from Because. If the feds found 3 AR-15s with the serial numbers scratched off, then why are they not adding it to the charges? Is that not a pretty big deal? Now, we know that that is an allegation, that is an underlying act as part of the overall racketeering conspiracy charge. That is a fair question. If the goal is to try to go after Sean Combs and convict him of federal charges, why not, from a straight point of view, just charge him separately, count 4 in the indictment, with firearms offenses?
That's a really fair point, and I think what the prosecution was trying to do here is stick to this theory that this is a sex trafficking case, that although firearms may have been located, those alleged firearms and the scratched off serial numbers are the underlying charge to the RICO Act, which is essentially a catch-all to everything that Mr. Combs is facing here. One of the most important things is to start with your strongest point and your strongest arguments, and I think the government here, their position is their strength is in the RICO racketeering activity, or RICO and racketeering charge, subsequently followed by the additional charges that essentially were indictment today. Can't really speak to as of why. The prosecution does have the discretion to determine what they are going to add in these indictments, as long as they bypass it, of course, through grand jury proceedings. So it's really hard to tell, but I think, in my opinion, they believe that the sex trafficking and conspiracy component is their strongest case.
Saf, I'll follow up with. Yeah,
I
Bradford.
just want to add on that. In my
Yeah.
experience with the government, and what she said is 100% accurate in terms of the strength and going with the strength of what's the best that you have. But also, I don't think they can prove anything with the guns. This is a 10,000 square foot house. It probably didn't have prints, probably didn't have his DNA on it, probably didn't have enough for them to charge him with it. So what they do is, and the government always loves to do this, is stick it in where it's an underlying on a RICO, so they can dirty you up, even though they can't prove that you had knowledge of the guns, that they were your guns, that this is a 10,000 square foot house. He's got security guards and other people coming and going. So instead of focusing and saying, like, these are his guns, and we can prove these are his guns, because they can't, we're going to say, oh, it's part of this RICO conspiracy. He's got a big house, but he's got guns all over it, and he's got people coming and going, and they're all part of this big RICO conspiracy. That usually is what happens with these type of cases.
And we have a question that I'll get to about RICO in a second, but I got to give everybody an update from court. The judge asked, why do we need two sets of motions, maybe about motions in limine, these evidentiary motions about what can be admitted into trial? And Combs' lawyer, Shapiro, says, we propose to file March 19th. The judge said, so ordered. Combs' other lawyer, Agnifilo, we want the identity of the people in the 404B letter. Could you extend your order about the enterprise letter to that? And AUSA Steiner, prosecutor here, the 413 notice was to put the defense on motion, to which Combs' counsel says, this is under seal. The judge says, and this discussion too? The prosecutor says, we can refer to the letter. Shapiro responds, be more vague about it. This is a little cryptic here, Safa, but basically, we've talked about this before on sidebars. There is an enterprise letter. We believe at least one, maybe two were filed, that basically lays out a little bit more of the allegations of the RICO enterprise, dates, times, places, in the sense to protect witnesses and victims' identities. It's been put under seal. What is this back and forth about? Can you make sense of what's going on?
I'm not quite sure. It seems that there may be information or witnesses that the defense is still looking to find out or ascertain who they are, and so that they can continue their investigation as they prepare towards trial. So I don't know what's stated in the enterprise letter. I do believe it's under seal.
Safa, they mentioned 404B, right? And that would be other acts, other crimes. I mean, how expansive are they making this prosecution against Sean Combs?
Absolutely, and it's very expansive, and that's one of the most important things as attorneys, and we proceed through these cases, is we make requests for what we call bill of particulars, and we ask for the government to particularize how they intend on proving the factual allegations in this case. And so I don't know if that enterprise letter includes or encompasses some of that information that ultimately should be provided to the defense as they prepare for trial, or if the government is still sort of hiding the ball at this point with who are the witnesses and what are the alleged activities specific to that RICO charge.
I'm going to get to more of the questions that we have. They're flooding in right now, so we're going to continue this conversation. But there's so much happening, the updates from court that I want to get to. So Bradford, the prosecutor in this case, said, the notice just tees us up for motion practice on if they will be allowed to testify. Many of these individuals who may never get their day in court are incredibly frightened by having their names disclosed to the defense. To which the judge responds, all right, Mr. Agnifilo or Ms. Shapiro, do you need the identities for the motion? To which Agnifilo responds, I think we do. The attacks don't usually relate to entirely legal issues. We don't want to have our hand behind our back. Some of them we know. Okay, so they obviously want transparency. They want as much information about the prosecution's case. There is this balancing act between what can be properly disclosed. What's going on here?
It's complete garbage. So, whenever I have like a gang case or I have a case with RICO, or I have a high-profile case where they're saying the guy's a dangerous guy, and all of a sudden we can't turn over. Sorry, we can't tell you all these witnesses we could use against you because they're frightened. Well, I get it, but that's what we're here for. That's what court is. That's why people feel the judicial system needs to be gutted. That's why people feel that there's no transparency, that when you get charged in a federal crime, that they get away with literal murder because they're not disclosing things that they should be disclosing, Brady evidence, and that's evidence that may assist the defense. There's all these different arguments that are made by the defense, and all these different arguments that I've made many, many times, where people are like, oh, well, that's not really Brady, or let's do a weighing. Listen, these are witnesses. This is a very important case. This man's life is on the line, and you're going to tell me that you're not going to turn over people that are making accusations, that are saying he's part of this thing, that this is his MO, this is what he did to me 15 years ago, and you're not going to turn that over so I can start investigating, and it's 2 months away, 3 months away from trial? I think that is the biggest cop-out, and you see the government do it time and time again on these cases, and it gets to the point where individuals, just a regular average Joe, gets so tired of hearing these excuses from the government or from the state that they're not going to turn over witnesses' testimony or witnesses' identities. It's really something that I think the judge should take very personally and say, listen, I understand where you're coming from, but we're going to turn this over to the defense attorneys, and we're going to have an order that says we can't, you can't disclose it to anybody else, or maybe you can't discuss it with your client for a week, or whatever it is. The guy is in custody. He can't only use the phone that's on tape record. So they're going to know if he's discussing these individuals or if these individuals' identities get out. So I think that they should turn over these names so that you can at least have some semblance of a good defense against individuals that are making very serious allegations against someone.
So I have another update from court, and then I'm going to go to two questions for you, Safa. They're kind of connected, but the judge just said, okay, I'm going to order the government to provide these names on Monday on an attorney eyes only basis, which would seem to suggest that maybe Combs wouldn't know the identities of these people. Motion practice starts Wednesday. The prosecutor said another option is for us to move first on March 19th, that they'd have to get to March 26th. Judge said no, it's 4 days, so they're working on scheduling. Safa, two questions that are related here. So first one is from Wayward Sisters. So what makes this a federal case? And then we have a question from Dad. I don't know if this is my dad. Hi, if it is. How is this a RICO case? Any law experts make sense of this or ever heard of this before? One-person RICO case? Because he is right now the only criminal defendant charged in this action, Safa. So what makes this a federal case? And also what makes this a RICO case if he's the only one being charged?
I'm going to answer the latter first. So it is very surprising that he is still the only defendant on this case. A lot of times with RICO cases, you see a number of defendants or co-defendants. And so it's actually been very surprising to me that there haven't been any additional defendants added on here. Now, with respect to the specific charges and why this is a federal case is because the federal government oftentimes has catch-alls. And one of those catch-alls is that anything transported via interstate commerce, they have jurisdiction over. And so there are already the legislations or the statutes that essentially are specific to RICO, racketeering, and organized crime, essentially alleging that this is a criminal enterprise and they've engaged in a number of underlying acts or activities, specifically kidnapping, arson, and a number of other activities. And specific to Mr. Combs' case, there's a portion of the indictment that reads that these individuals who engaged in sex trafficking or sex workers were transported from one state to another, which is essentially interstate commerce, which the federal government has jurisdiction over those things. And so ultimately, that is a big reason why the government here has taken jurisdiction over this case. I think there's some statute of limitations issues with respect to other states and whether New York or California, and ultimately, those cases opted not to be prosecuted, and so we're dealing with the federal jurisdiction here in that indictment.
Well, by the way, just if anybody's joining us, I want to let everybody know we are taking your questions right now on YouTube about what is happening live in court right now. We're also doing live updates and about the case in general. So make sure to submit them. We'll answer them on air. And again, Elizabeth Milner, our very own reporter, is in that courtroom. She's going to come out later, give us her sense about what she saw happen in there. We have some more questions coming in as we also are getting more updates. So Bradford, I'll go to you. We have a question from Highs Motivated 27. Why did Diddy apologize for the beating in the video that surfaced if he didn't do it?
Yeah, great question. Listen, we all saw the video. We all saw what was on the video. We can use our own judgment as to what we saw in the video and how it occurred and things of that nature. And I think that at the time he apologized because he thought in his mind, and I'm sure he was advised, that that would be the best route to take in order to mitigate the circumstances that were going on. Now, it could be that he was truly sorry for what we all saw in that video and that he wanted to put that apology out. But generally speaking, people that apologize after the fact and not before the fact are usually apologizing to mitigate the circumstances that they're under. Now, do I know that to be a fact? No. Do I think under my 28 years of experience that happens a lot? Probably 95% of the time. So I think that he apologized to try and put a fire out, to try and mitigate what was going on, and to try and alleviate some of the bad press and also the possible criminal and civil charges that were coming down the pipe.
And by the way, I mean, I think the defense is suggesting, yes, it was an unfortunate incident of domestic violence, but it's not an incident of sex trafficking, where the prosecution would counter. We have a witness who was in that hotel room that was, allegedly about to engage in this. It can be a freak off, a commercial sex act, group sex, a legal group sex of some kind, and that's how they're going to tie it to the overall charge. So we'll see where that goes. Okay, I have a question for you, Safa. Carly Rodriguez asks, if CNN did destroy the video, could they face legal consequences?
Get them.
It's certainly possible. Tampering with evidence is always an option. So it'll be interesting to see. But I think one of the things that the defense is going at here specific to that, and in the law we call the best evidence rule, is that if there's a key piece of evidence or material piece of evidence that's being presented at trial or is going to be presented at trial, in theory it should be the original copy. So it should be the original copy of this footage, not anything that was clipped or doctored up or altered by CNN whatsoever. We don't know who has the original footage at this point right now either. We don't know if that's been disclosed to the defense or the prosecution. Have a feeling the prosecution probably does know who has that original footage. But the argument to be made here is that what is required is that original piece of evidence or that original video footage. And if the court can't, if they can't provide that to us, then certainly, and it's not destroyed, it does exist somewhere, then it should be kept out from the trial because it is not the original evidence in the best evidence rule.
Question for you, Bradford. Interesting one. This is from Wolves in France, and I'm not sure what this means exactly. Is there a compensation tier? How does the judge calculate it? Thank you for all the super coverage. I'm tuning in from SW France. Well, thank you for watching. It seems to me that this might be a confusion between criminal law and civil law, unless I'm looking at it the wrong way, Bradford. What do you make of this question?
I think so. Sometimes in criminal cases, you can have restitution that's owed in different kinds of criminal cases. In this kind of criminal case, I don't see that being an issue. And there is a civil matter that's going on, but not with the most important parties to this criminal case, because that has been settled already. So I don't believe that, in this criminal case, I don't think there's going to be a restitution issue. That would be the only thing that would be some sort of money issue. And I think that the individual is probably thinking of a civil case that has nothing to do with this criminal case.
We have an update from court. Judge says next pretrial conference is April 25th. If we need more after that, we can do it. The prosecutor says the government intends to produce 3,500 material on a daily basis as we get closer to trial. The judge said, I saw some nods from the back. And Agnifilo, Combs' attorney, says that's fine. Safa, 3,500 material. Isn't this in relation to witness statements, right?
Yes, and so one of the things with discovery and all of these sorts of things that we're discussing is that there's an ongoing obligation from the government to provide and turn over these materials on an ongoing basis. Me personally, I think all of these things should be turned over well before trial so that there's no surprise, so that the defense has the ability to investigate everything thoroughly. And I think it's quite unfair that the government gets to hold on to these things with such a short notice or such a short time frame between the beginning of trial, which essentially is scheduled to begin a week later, at least during the voir dire process. But yes, that is correct.
Question
That's
from
what's crazy, by the way. It's nuts. When you're in, like, that's why I always say, like, people really need, if a person sits and watches a federal trial, and I've had many, and where you sit there and someone takes the stand and you say to your client, who's that guy? And he says, I don't even know who that guy is. I don't even recognize him. And they're like, oh, by the way, here's his statement as he takes the stand. And here you're reading a 3-page statement. This guy's talking. And you're reading a 3-page statement, and they don't have to turn. There's no mandatory turnover. Now, some judges are great, right? And they say, hey, turn over the stuff 3 days before trial. Let them at least so they can review it, turn it over a week before trial. And they call this Jenks material 3,500, where there's statements that are ongoing. And I don't hold their feet to the fire on everything, because sometimes an agent may get a statement at the last minute that maybe they weren't able to get. But when you have those statements, there is no reason not to turn those over, but for sandbagging. And it's really another unfair area of law that you get to experience, when you're in federal trial. And I remember my very first federal trial where I'm like, hey, where are these witness statements? Oh, you'll get them when they take the stand. And
You'll get them at the lunch break. You'll get them at the lunch break, yeah. It really happens. It really happens that soon before someone.
It depends on the prosecutor and it depends on the judge. But when you have a very,
use your words carefully.
I'm figuring out how to say this. When you don't have a good relationship with the prosecutor and you are going toe to toe, and it is, Ivan Drago and Rocky in the courtroom, they abide by the rules like this, and they say, hey, you're not entitled to it until they take the stand. You're not entitled to it until this time, and you don't get it. So it's just like this little game that everybody plays, and what people don't realize is they're playing a game, but someone's life is on the line with this game that they're playing. And that always is what gets me fired up, is that, you're playing these little discovery games, and what is hanging in the balance is not just someone's life, but overall the big picture of justice. What is justice? And that's the problem that a lot of people have when they watch these trials. And I think that's why cameras generally aren't allowed into federal court, is because no one wants to see, like, here's your discovery when someone takes the stand, because people would normally be outraged by that.
Okay, I have quite the update from court. So the prosecutor said they have told us they will not seek a trial delay, presumably meaning the prosecution, and presumably seeming the defense. The defense comes back with Mark Agnifilo. There is no application with regard to the trial date. We recently came into possession of a lot of medical records. We want an expert on prescription medicines. Judge says okay. And now we are getting word that the hearing is over, which is very interesting because I feel like there was a lot more issues they needed to get into, but it appears maybe not at this point. So now we're going to be waiting for a possible press conference outside of that courthouse. And again, Elizabeth Milner's inside that courtroom. She's going to come out. She's going to clarify anything we don't have questions about, and also tell us, what did Diddy look like? And what were her observations of him? And was anybody in there supporting him? Okay, before we get to that, we have more questions coming in, and to talk a little bit more about this. So Safa, one of the questions that we got is from Ann Brown. Will there be any further superseding indictments?
You never know until you know. It would not surprise me with this prosecution team if on the eve of trial or at the 11th hour, there's another superseding indictment. That's why I think it's always important, and again, as a former prosecutor, is that you gather all of the evidence that you have first, and then you put your case into grand jury for indictments. And you indict them on your strongest points and your strongest arguments, and anything that you think fits and is sufficient. Once you get into a second or a third superseding indictment, then as a defense attorney, I look at those things like you may not have the strongest case, or you may not have had a case as strong as you think you did if you have to continue to add and alter charges. You've had this evidence for quite a bit, at least since last year. So why is it now that you're now adding these additional charges and a superseding indictment? But it would not surprise me. We won't know unless we get there.
By the way, this is a live look that we have outside of that federal courthouse in downtown Manhattan. We're waiting for a press conference. We're waiting to hear from Elizabeth Milner as well. Question for you, Bradford, from Oh No, I Said My Opinion. I kind of love that. Doesn't he have the right to face his accusers?
Yeah, I mean, he's gonna face his accusers. You know, and when I was talking about before, when we were discussing whether or not they're going to disclose those names, I don't want to say I'd be a great federal judge, but it's exactly the ruling that the judge said. You know, it's you got to disclose these names. You're not going to hide these names from somebody and use some excuse that they're afraid to come forward. You're going to describe these individuals. You're going to give them their names. You're going to give them their information so they can have some semblance of a defense against what they're saying. So, yes, he's going to have his day in court. He's going to face his accusers, as many as they have. And my guess is, like, they added that paragraph to add more witnesses, right? So they're going to add more witnesses. This is a case, in my opinion, that the prosecution will try to dirty him up as much as possible on anything they possibly can, because I think they know the trouble with their case. And the trouble with their case, in my opinion, is the same from when I opened. And that what I opened with was, you are going to have to say these sex offs, these freak offs, these things, these multiple individuals. When it boils down to it, then it only is a girlfriend, a prostitute that's getting 10 grand an hour, and Diddy. So now you're going to have to come up with, how did you sell? And you sold me a Ferrari, but sitting outside is a Yugo. How are you going to sell that to me, right? So that's the problem the prosecution has here. And like I said, legally, is it sufficient? Maybe. But is it in the minds of a jury when you see some guy who's making 10 grand an hour and you're going to get evidence that the girls were there and they were doing it and they were contacting these individuals on their own in some instances, I've heard. When you start hearing those things, I think it makes the case more difficult to say this is sex trafficking.
I agree. I think that there is going to be an important, clear narrative the prosecution has to assert in order to have this jury accept and understand these charges. This is not the most straightforward case, but it'll be interesting to see who the witnesses are and what that narrative is. I will tell you, and this is interesting, Safa. So, by the way, I love the idea of Judge Cohen, Judge Bradford Cohen. Fair but firm,
yes,
Judge Cohen.
Fair but firm.
There we go. Safa, let me go to you on this. We have a question from KXTTY Meowsers. Could Diddy be charged with tampering with evidence? Now, my understanding is right now, he's hit with multiple acts of tampering with a witness, victim, or informant, not as individual charges, but again, underlying charges, underlying acts, to be more specific, as part of the racketeering conspiracy case. Could he be charged, either a part of that or separately, with tampering with evidence?
That's always a possibility. Again, with respect to that type of charge, I think if they were going to charge it, they would have already done it in that manner. Of course, we don't know if everything's been turned over to the defense at this point in time. We don't know, and we've still got the witness names that are outstanding. So could something happen between the time of those disclosures and the time that we get to trial, or as these individuals are testifying? Absolutely. So that is a possibility, although it doesn't seem to be that at this point in time.
Bradford from Rel, do you think it matters who gave CNN the tape?
That's a good one. Does it matter in the criminal case? You know, it could. It just depends on how they got it, when they got it. Again, it goes to the chain of custody, right? So if this person is is really dirtied up, if this is someone who has fraud charges in his past and all these different things, is it possible that it could be added to Mark's motion by saying, hey, they only have this other video. This guy says he's got the quote unquote original, but this guy is not a good guy. He's got fraud in his past. We need to put him on the stand and find out where he got it from and how he got it. Certainly it could. I don't know if it's going to. I think that would lend itself more to like how CNN got the video, what they did with the video, and things of that nature to hold them in contempt and or have some sort of investigation on why they allegedly destroyed the original tape.
So we have two questions that are very similar, and I'm going to go to it. We have one from Movement Freedom. How long is his max sentence at this point? And also from Nanny X3, how much time can he possibly get? So Safa, I'm going to throw it to you, but first I'm going to lay out what the actual the range is here, and you tell me what's a possibility if he's convicted across the board. So I'm actually taking this from the press release from the Department of Justice when he was indicted. So the racketeering conspiracy carries a maximum sentence of life in prison. The sex trafficking by force, fraud, or coercion carries a maximum sentence of life in prison and a mandatory minimum sentence of 15 years in prison. And the transportation for purposes of prostitution carries a maximum sentence of 10 years in prison. What do you think he would get, Safa, if he was convicted?
Oh, what he would get is going to be interesting, because one of the things that happens in federal court that is different from state court is we have a chart that are the sentencing guidelines, and where Mr. Combs would fall on those sentencing guidelines is going to depend on how he's categorized, any prior criminal history he may have had, any aggravating factors or anything of that sort. And I'm sure if Mr. Combs is convicted, his attorney is going to set forth a mitigation package to the judge, and at the sentencing hearing will provide many things that would mitigate the sentence that Mr. Combs could ultimately face, which Mr. Combs may never see the light of day again if he's convicted on these charges. So that is certainly a possibility. That's how serious they are. There is the possibility that after a trial, the jury may come back guilty on some charges and not guilty on others. Hypothetically, if the jury were to come back not guilty on the charges that carry the life sentence, but come back guilty on a charge that may carry a penalty of 10 to 15 years, then he would be sentenced as such.
By the way, we have a question here we're waiting, by the way, for Elizabeth Milner. Our word is she might be jumping on relatively soon, so as soon as she can, we'll jump out to her. Question from either Michael or Mikhail Jordan. Michael Jordan, Mikhail Jordan. When and if will there be another bail hearing? It's not going to happen. They've abandoned that issue a while back. But there is a question for you, Bradford. This is actually a really good question. From Master Shake. Will there be reenactments during the trial? How would that work?
I tend to feel that question was loaded. But
what would ever give you that idea?
I would answer no. I don't believe there's going to be any reenactments during the trial. This isn't one of those cases that there will be reenactments.
Would you like a different question? I'll give you a different question. Stacy D asks Bradford, if he's found innocent, can he be tried by the state again for different charges?
Actually, he could be charged by the state with the same charges. So that's the difference in state and federal court, in terms of, and when I say the same charges, I don't mean the same statute numbers. State crimes and federal crimes can be charged simultaneously for the same thing, and you can be charged twice. And we've seen this done in the past on cases that, bring outrage to society. Where, an individual maybe got off on the state charges and then the feds are like, hey, we didn't like that result, so we're going to charge them federally. And or the other way around, where the feds have walked the guy, all of a sudden you get a not guilty on a federal case and the state's like, let me have a whack at it. I had a case in Tampa where I got a not guilty on a federal gun charge, and then the state charged him with murder with the same gun. And of course I won that too. But they tried. But they tried.
Yeah. We have a question from Life's a Gamble, who's been very patient, been sending a lot of questions in the chat. This I'll go to you, Safa. Will all of these civil cases be exposed when the trial starts? And I think there's, over now 30 lawsuits that he might be facing, maybe even more. Will all of these civil cases be exposed when the criminal trial starts, Safa?
Do you mean exposed like in the criminal case? I'm going to assume that maybe if you're asking, is there going to be a reference to the civil cases throughout the criminal
I guess
trial?
those allegations, are they going to be a part of the criminal case or be talked about or discussed in some way?
Well, I think the basis for some of these criminal charges outside of Ms. Ventura's lawsuit against Mr. Combs, some of the allegations in those civil suits are the basis for this indictment. And so I think that some of them go hand in hand. I don't know that we will specifically hear, and this will go to credibility to some extent. And, if Ms. Ventura testifies, the likelihood that she filed a civil case against Mr. Combs is going to come into question, and what she received. And all of those things will weigh to her credibility. So if she accepted money, which we know she did, or there was some sort of settlement, it will come into play with respect to that. I don't think the prosecutor is going to get up on their opening and say, Mr. Combs is XYZ, and not only that, but he has 30 civil cases, that are pending against him. I don't think they would say anything like that, but some of the factual basis that are alleged in the civil complaints will be referenced in the criminal case.
So a couple of questions we have here from Maria Gothica. Is the trial going to start on the 5th or be pushed back? Right now it looks like it's going to start on the 5th, although it seems that the openings are going to happen maybe at the 12th or the 13th. Diabilita Beauty, will the trial be open to the public? I mean, Bradford, generally speaking, we know there's no cameras there. We know that media will be allowed in. What is the ability of the general public to come in and watch what's happening?
Depends on the courtroom. In New York, there's one bigger courtroom, but most of those courtrooms are pretty small. They fit maybe 70 people in the pews, 60 people in the pews. So I'm sure they're going to have some sort of lottery or line. They usually have some sort of register your name the day before to see if you can get in type situation where they let some just average Joes in as opposed to having your credentials. So yes, all courts are open to the public, generally speaking. It would have to take a really big act to close the doors of a judicial hearing. There are some circumstances where there's juveniles or there's marcy law issues. There's some kind of issue that doesn't allow just general public in. But in this case, I would imagine that the general public will be let in on some level, but not like, everybody in line, that there's 300 people in line, everybody's getting in. I don't think that's going to happen.
Got another question because from Life's a Gamble has asked a bunch of questions here. This is a good one. Saf, I'll go to you. What are your thoughts on the new recent lawsuit that includes the police chief having ties to this? Will this be a separate thing? Now, I don't know if you had an opportunity to see what this is, Safa, but this was an amended complaint filed by Ashley Parham that names a number of different defendants. And apparently there is an allegation that the Maui police chief, John Pelletier, was involved in this, that there was a cover-up, that he is accused of being essentially a security guard for Sean Combs back in 2018, that at the time he was this Las Vegas police captain. He posed as a deputy in California, responds to this alleged gang rape allegation involving Combs, and then allegedly takes Parham and another plaintiff at gunpoint, restrains them, refuses to let them call, for help or an attorney, and then tries to cover this up. It's a startling allegation. We know that there's other high-profile people named in this. I don't know if you've had an opportunity to see it, but what are your thoughts on it?
I have not had an opportunity to see it, but those allegations are definitely pretty gruesome if taken as true. I think that one of the things that we always have to remember is that when somebody is making an allegation or when somebody is charged with a crime, they are simply allegations. They are not facts. They're not facts until a jury or a judge, if you opted for a bench trial, were to find them as facts. So I'm not too familiar about this new civil suit. Don't know if it could come into play with the criminal case. I doubt it will, unless the prosecution has some relevant information that they think that they can use, and they'll try to use it, of course, if they can. So I'm not too familiar with that to really make that determination.
Bradford, let me go to a different question for you. This is from Sharon Clark. when will anyone else be charged as well as Diddy? It's kind of the Ghislaine Maxwell effect, right? She was charged about being and convicted of being part of this sex trafficking plot and ring, an international ring, and yet she was the only one charged. Is there anybody else who's going to be criminally charged alongside Sean Combs?
I don't think at this point, I don't think so. I think that maybe after a trial, maybe it shakes out where other people, might get charged. I think that what's unusual is there's not a lot of unindicted co-conspirator number one, unindicted co-conspirator number two. There's not a lot of that in this indictment. And when you see RICOs in the past, you would see, oh, okay, there's unindicted co-conspirators. There's another 15 guys that are going to be unindicted co-conspirators. And although they're not indicted in this case and may never be indicted, they are part of this, this RICO. That's what makes this unusual. I think it's unusual. I think they threw the kitchen sink at this case because, like I said, I think they have some worries. And it's shocking when you say the government might have some worries with their case because they have a 98% conviction rate. But, on these high profile cases, no prosecutor wants to lose, number one. Number two is the Southern District of New York hates to lose. They don't like losing. They're like me, kind of, but worse because they work for the government. So they don't like to lose. So if they can throw the kitchen sink at you, they're going to throw the kitchen sink at you. All they got to do is hang you up on one of those counts, a 15-year min-man, a 10-year, a 20-year, and then they can say, to take their hat off, put it on the coat rack and say, hey, we got them. That's all they need. So they don't need the life felony. They just need the 15, 20-year.
Well, Bradford, I'll follow this back up to you. We have a question from Rel directed towards you specifically. Do you think you could win this trial, Bradford?
Yes, that's funny. Listen, as a defense attorney, and I'm sure Safa will agree with me, there's never a time where I take a case that I think I'm going to lose the trial. I don't care how bad the facts are. I don't care what my case is. I don't care what the charges are. It does not matter to me. If you have a defense attorney that takes a case that he thinks he's going to lose, you need to get a different defense attorney.
Yeah.
And to my chagrin, my bad habit is that I fall in love with my cases so much so that I think I'm going to win every case, like every single case. I just expect it. And so, when it comes to this type of case, I think he's got some defenses here. I think you're going to expect, some people might not expect to see the fireworks coming from the defense. But I can tell you, and I know Mark, and I've seen him in action before, I can tell you there are going to be some surprises at trial that I think will take people's breath away in terms of what they've heard from the government and what they're going to present at a trial. So I don't know. The answer is I don't know if I could win this case, but I think I could. I mean, I think I can win every case.
Yeah, and that is why you are Bradford Cohen. So, Safa, this is an interesting question from Great White 9995. You mean there are no videos of the freak-offs? Now, let me tell you my experience. I've been covering a lot of this on Sidebar. Based on the pretrial filings, it seems to me the defense is not asserting that there's not videos, not even videos of freak-offs. They might acknowledge that that's what it is, but that it's consensual, that it's all consensual sex. Is that what you've seen as well? I mean, I don't think anybody's denying that there might be videos and they might be determined or categorized as freak-offs.
Absolutely. I'm willing to bet my law license that there are absolutely videos. I know that there was a significant amount of discovery that was provided in this case. There was discovery and search warrants for his iCloud and, technical footage and all kind of things. So I'm fairly certain. And the way that the prosecution alleges these acts took place, down to, people in the enterprise that were setting up the lighting and, making sure they had proper supplies for these freak-off events. They knew that information because there were videos, and there are videos. Could we see some of those videos played at trial? Absolutely. But of course, we'll see. We don't know as of yet, but I'm sure that there are videos. I'm sure there are videos of the freak-offs, and there's a very good chance that those will be played at trial.
Safa, let me
Because
follow
one
up.
of the things the prosecutor is going to have to do is go to prove the point that this was against the person's will. Say
Right.
hypothetically that CNN video is kept out under best evidence. And now we have just the freak off videos. The prosecution's going to try to piece together their case by saying that here we have the sex worker in the video. They were paid X amount of money. They were transported to California, hypothetically, via New York or wherever they came from or wherever they were going to. And the activity in the video shows drug abuse, it shows violence, it shows threats or coercion, or maybe a part of it may, and then they continue to engage in these freak offs. That is the best piece of evidence. Footage is the best piece of evidence, and we certainly will see that here.
Safa, let me just follow up with another question from B Cause. If somehow Diddy walks on the federal charges, can any of the civil charges, they're not necessarily charges, but civil claims, be turned into new federal charges later on if he is found guilty in the civil courts? Now, you're not found guilty in the civil courts, you could be found liable. But does that make sense to you? If he's found innocent, if he's found not guilty in the criminal case, can they take any of the civil cases, the allegations in the civil cases, and mount that into further charges at maybe a state or federal level?
I doubt that's going to happen, because one of the things that we do know has been happening is that the government has been monitoring those civil cases. And some of those factual allegations in those civil cases have made their way into this federal RICO indictment, or at least there's going to be mention of it. So I don't think that's going to be the case. I don't think that's going to happen. I think anything used from the civil cases is going to be used in this specific prosecution to the extent that it can be used, because civil court in that realm is totally different from criminal court. Criminal court, we have the highest legal burden in the country, proof beyond a reasonable doubt, and that's what's required as opposed to in a civil court. So I don't think that's going to happen.
Let me ask you this, Bradford. Jesse K asks, will these videos also be seen by the public? And let me couple that also with this. If there are these videos that are played in a courtroom, aside from the jury seeing it, aside from the judge seeing it, aside from the lawyers and the defendant seeing it, is the media going to be able to see it? Who's going to see it? Will journalists? Will the public? Who's going to actually be able to see these videos?
Depending on how. So there's a couple things there. It's multiple. It's not just one answer, right? Depending on what courtroom they're in New York, there are courtrooms where there are specific screens for the jury that are right in front of the jury. Everyone has a screen, and then there's a screen for the judge and a screen for the defense and a screen for the government. Sometimes they'll just play it on those screens, and then the people in the pews don't get to see what's on those screens. I've seen that happen in these type of situations where there's sensitive material that's being played. I've also seen it happen where there's one big screen and it's played and the jury's sitting there, the lights go down and there's a big screen and everyone gets to see what's on the screen. The judge also has his own or her own screen, or they move and they watch what's on that big screen. So that could be done. The third thing is it could be that only when they're showing the specific video, they could try and exclude the press and the public, which is the least likely of the three scenarios, because they want as much transparency as possible. But again, it's one of those weighing circumstances where is the individual's privacy rights that's in the video worth more than the transparency to the press and the public. It could be that the judge says, hey, listen, only when we play these videos, you'll show the video, whatever it is, right. Only when we show this video, we'll clear the courtroom. It could be, but I think more likely it's going to be personal screens that everyone will be able to see, the defense, the government, the prosecutor, the judge, and the jury.
So we're still waiting for this live shot outside of the courthouse. We're waiting for Elizabeth Milner. We're waiting to see if there's going to be a press conference. But I want to get a couple more questions in with you guys before I have to sign you off. We have another question, Safa, for you. This is from Bahamas Racing. Many are surprised that no others have been charged. But could Combs Enterprises be among them, having entered into a plea agreement with the prosecution? So I guess the question is, was his corporate entity, or, I'm not 100% sure, did they work out some sort of deal to be cooperating witnesses, people that are executives or employees of his businesses, to enter into a deal with prosecutors to be witnesses against him? I'm not entirely sure I understand the question, but what do you take away from it?
So, with respect to the indictment has charged Mr. Combs under a number of names, and they allege that he is the criminal enterprise. It's his criminal enterprise. It's at his direction, and all of those sorts of things. Could individuals that work for that enterprise or allegedly work for Mr. Combs be used as witnesses against him? Absolutely. We haven't heard about anybody being charged as of yet. Sometimes what the prosecution likes to do is say, hey, you're going to cooperate with us, and if not, we'll file charges against you. So that could be the holdup is, nobody's been charged as of yet because they want to ensure that they're going to come in, they're going to testify, they're going to cooperate. It's important for defense attorneys to know that these individuals are cooperating as well. And in some statutory basis, that is also required to be turned over to us as defense attorneys, like in the state of New York. But it is possible that those individuals will be used to testify against Mr. Combs. And also, I know that there are going to be individuals that are going to be testifying from the enterprise or alleged enterprise or Bad Boy Productions or whoever that will be testifying on behalf of Mr. Combs as his witnesses as well. So it's just going to depend on who ultimately comes to trial.
Let me finish this up with one final question to Bradford. It's actually two questions I'm combining. This is from Mandy Siago, who asks, will this be like the Adelson case and multiple people tried after conviction? That's, of course, about the murder for hire plot of FSU law professor Dan Markell, where you had multiple people charged and other people charged. And this is from Movement Freedom. Who else are they looking at in this case? Surely it's not just him.
Yeah, it's very unusual the way they did this case. And like I said, my gut feeling is they're going to try and get him and convict him and then see if he gets, 15, 20, 25 years, see if he'll flip on somebody, because he's not flipping now, right? And if they get him and he gets 20 years, 25 years, 30 years, that sometimes sways individuals into saying like, okay, maybe I will be a snitch. So it could be that they're waiting to see if he gets convicted. And then if he does get convicted, to see if he will flip on individuals that they could get, because they might need his testimony in order to lock those individuals down, because some of those individuals may be very high net worth individuals. And the government hates nothing more than someone that actually has the funds that can actually fight them on an effective basis. They hate that more than anything. So if you are worth $50 million and can sink $20 million into a lawsuit, into a criminal case like they do, and you can actually have a good defense, they hate that. They despise rich people because they hate people that actually have the wherewithal to fight them effectively. The answer is there should be other individuals. I don't know what they're planning on doing. I think that they may be falling after this case, but it could be that all they wanted was Diddy and everyone else is going to cooperate and everyone else is going to stand there and point the finger, and that's the bad guy.
Well, we shall see. What I can tell you is we have broken down a lot so far. We have more that we're going to break down. I have to excuse Judge Bradford Cohen, and I have to excuse Safa Robinson Ferrer at this point. Thank you both so much for coming on. Really, really appreciate it. You both are terrific and love your insight. So thank you both for coming on.
Thanks, Jesse.
You got it. Now, we're going to take a break. When we come back, we have Elizabeth Milner ready. She was inside that courtroom. What did Diddy look like? What did he say? How did he appear? Any movements? Anything we can get a reaction to? And there's a couple of things we need to clarify about what happened in that courtroom. So stay with us here on Law&Crime. We'll take a quick break. We'll get back to more of your questions and analysis on the other side. All right, welcome back, everybody. I'm Jesse Weber. We have this special coverage of a live Diddy hearing in downtown New York in the federal courthouse. It wrapped up a little bit earlier on, but that's okay. In case you missed it, we have with us Law&Crime's very own Elizabeth Milner, who was in that courtroom. And Elizabeth, it's so good to see you. I have so many questions for you. I want to take one at a time. First of all, how did Sean Diddy Combs appear? And was there anybody there in attendance for him?
Well, honestly, Jesse, I feel like Diddy's appearance was probably the biggest story that happened inside that hearing. There was kind of an astonishing whoa when he walked inside that courtroom because he appeared noticeably grayer. I would even kind of equate it a little bit to Santa Claus, but he just appeared grayer. His hair was a lot whiter. Now, remember, the last time I was inside one of Diddy's hearings, that was back in December. We're in March, so that's just a 3-month time span of just that intense grayness. So either him being at MDC Brooklyn for this amount of time is weighing on him, this federal case is weighing on him, maybe even his fall from grace entirely is probably weighing on him, but he just looked visibly different. I will say, though, last time he appeared thinner. This time it seems like he did kind of pack on a little bit of pounds, and I don't say that in a disrespectful way at all, but he did seem to kind of put his weight back up from the last time that I saw him. But it really was just kind of a stark difference. Now, he was graying a little bit in the last hearing, that is no doubt, so it wasn't too big of a jump. But again, a lot of us who were sitting in the gallery, a lot of the reporters were just kind of like, whoa, because of just how astonishingly grayer he appeared during that time. Now, as far as who was inside that courtroom, it was, as far as his family goes, a lot smaller of a group than we've seen before. We've seen times where all of his kids, maybe with the exception of his now 2-year-old daughter, being inside that courtroom, putting up a united front. But again, this was kind of a smaller group this time. It was only Diddy's daughter, Jessie Combs, and it was Diddy's son, Christian Combs, also known as King, as well as Diddy's mother, Janice Combs. So, of course, when Diddy comes into the courtroom, that's the first thing he's looking out for, is that he's going to be looking out for his family. He's going to be waving to them, you know, kind of mouthing "I love you" and all of that sort. And that's what happened as well as when he was leaving, too. I even saw him kind of mouth "Hi, Mommy" to his own mother. But, you know, his son, Quincy, wasn't there. His son, Justin, wasn't there. The twins weren't there. And, of course, his youngest daughter, just 2 years old probably at this time, Love, wasn't there. So really it was just a smaller group of supporters this time, and it might have just been scheduling. It might have just been the fact that this wasn't going to be a big hearing necessarily, but also we didn't know what we could really expect from it. But, you know, it was just kind of different as far as what we've seen before, where they take up an entire row in the gallery, to just being in a small little corner there. But it appeared that Diddy was just happy to see him, happy to see his family, happy to have support in there for in the courtroom. And as far as even just at the defense table too, another noticeable difference that I thought to myself was just the fact that Anthony Rico was no longer there. Again, he filed a letter kind of saying that he can't be on the case anymore, and that was just a few weeks ago. And so that to me was kind of a stark difference from last hearing to this hearing.
Defense attorneys basically said there's no way I can continue. Not entirely sure what that even meant. By the way, it was interesting when you mentioned his appearance. It could be the stress. It could also be, and I have no way to confirm this, he doesn't have access to the same kind of beauty regimen as he might have had on the outside, and whether that meant dyeing his hair or whatnot. I mean, he's not the youngest guy, so it's something I thought about. Okay, so I want to now get into the substance of this hearing. A big part of this hearing was regarding the CNN tape. The tape of Sean Combs purportedly beating Cassandra Ventura, who by all accounts appears to be one of the key victims in this case, victim number one, to be more specific in this case, that there was this allegation regarding what CNN did to this tape, and there was back and forth. Remember, this was published in March of last year. No, it was May of last year. So talk to us about what the back and forth was regarding this tape, because I have to imagine it could be a key piece of evidence in this prosecution.
And like you had mentioned, Jesse, a key piece of evidence, and that's what the government was trying to argue there, that it is critical to their case to have this video admitted. Now, I will preface it and say this. The judge made no type of ruling on it, but he did kind of make a big suggestion. So before I get into that, let me just say the defense argues, and they kind of outlined this in their letter, that they believe that the video is deceptive. They have a forensic examiner who says that they put the video into editing software, and that CNN put the video into editing software, but that the time times were changed, the sequence was changed, they covered up the timestamp. But let's face it, Jesse, we all saw that video. Whether or not CNN did allegedly speed up this video, or whether or not that they kind of framed different pieces and different sequences, it never takes your eyes kind of away from the fact, or that we saw with our own eyes, Diddy gruesomely beating up Cassie Ventura. It was terrible. It was really shocking. And, you know, we say it's shocking a lot, but I mean, I just remember watching that video because it did play on a loop on CNN that day. And it was just terrible to watch. And we all saw Diddy kind of make that apology video afterwards. So for them to kind of have this argument about the CNN video in the first place, about it being altered, all of that sort, well, their client already admitted to doing what he did. But again, we still have to kind of put out allegedly here and there. But as far as the government wants, they want that video admitted into evidence. They want to use that video because they do believe it is critical to their case. Whereas the defense, it seems like they're kind of gearing up to put a motion in place to kind of suppress that video from a jury ever seeing it. But you kind of can't help but think, did a juror already see it? Did a potential juror already see it? So this was the judge's recommendation. They wanted to see if there was a way, maybe the defense and the government, who they kind of seem that they are working things out, kind of outside of the hearings, outside of the court, but they were seeing if there was a way for the defense to kind of place together the video and the way that they believe originally happened and see what the government says about that. Now, if they can't come to a decision from both sides, then that's when the judge will step in, then that's when the motions will be filed, and then that'll be taken up at another hearing. But it seems from the government side of everything that this piece of evidence is going to be critical to their case. I mean, even taking a step back to just last year, a lot of people did not believe Diddy's alleged victims, whether it be in the lawsuits or anything like that, until that video came out, until they saw with their own eyes just Diddy putting his hands on Cassie Ventura. And again, this was back in 2016. But just even thinking from her standpoint, seeing that video on a loop, knowing that it's been released to the public, yes, justice there in the sense that people now believe her or may believe her. But at the same time, when we saw that video, just shocking, just astonishing. But it seems like this will be a matter that'll be taken up at another time. No ruling was made today as far as whether or not it'll be admitted into evidence in trial, but the government made it clear they want this piece of evidence in that trial.
And it's interesting because, you know, the defense, they can't deny what the video is, but they seem to be denying the context in the sense that this might have been a domestic spat, but it's not necessarily evidence of sex trafficking. And as I mentioned before, the prosecution would come back and counter that and say, well, where was she running away from? She was running away from a room where there might have been a sex worker in that room, and this is further allegation of an illegal sex act or freak-offs or things of that nature. Now, I want to move on to something else. The names of people in this case. Another big theme that came out during the course of this hearing is regarding identities and names. And you and I both know, Elizabeth, this is something that has been litigated between the prosecution and the defense quite a lot leading up to this hearing. And there is terms about enterprise letters, about the prosecution putting in sealed letters about more specific examples of what is racketeering, what are the dates, what are the names, what are the places. The idea of names of people in this case, are they referring to witnesses? Are they referring to alleged victims? What happened today regarding the identities of people in this case and whether or not the defense will know who the prosecution plans to call?
And this is also an interesting part in the hearing, Jesse, as well, too, is that it seems like they were kind of talking, in legalese in particular, but also because a lot of that information was sealed. And the defense kind of made it clear because at one point when the government was making their stance on it, Alexandra Shapiro stepped up and said, hey, Judge, this is under seal. Obviously, she didn't say that verbatim, but she kind of made it clear to the judge that she was cautious about just kind of revealing everything about the particular enterprise letter. But one thing that the government said that stood out to me was just how fearful some of these potential witnesses are about having their names out in the public, about having their names released to the defense. And that should also kind of go to, we talk often when we're covering Diddy's stories, just about the power that he had either over the industry, over his employees, over alleged victims that he had, former girlfriends, all of that stuff. But the government did make it clear because, they couldn't get into into much details about that particular part because some aspects of it, from my understanding, were under seal. But one thing the government did make clear is that some of these witnesses don't want their names released out into the public. So they are going to kind of come up with a solution. From my understanding, it's that the government will turn over that list over to the defense. But you can imagine how fearful some of Diddy's potential, or not potential employees, but how some of the people who had worked under Diddy, whether it be for years, whether it be for a few months, could be knowing that they could potentially testify more into what was going on, as the government puts it, in the Combs enterprise.
And then the final point I want to mention and get some clarification on are timelines. I'm still shocked that this trial is going to happen by May 5th, 2025. It's only a few months away. And the idea about pretrial conference, jury questionnaire, jury selection, a motion schedule, it seemed to me that the defense got a win today in what they wanted for a schedule. Talk to us about what we can expect, some key moments coming up leading up to May 5th.
Yeah, it looks like that final pretrial conference is set for kind of late April, before the jury questionnaire is set to go out. And essentially the defense, they wanted 300 jurors a day. That's a lot of people, but it seems like they want everything to kind of move at a quick pace. But to your point, Jesse, it did seem like the defense did get a win, because one thing as well, too, is that the defense wants these jurors to be sequestered when they're doing the questionnaire. So they want to be able to speak to these jurors one-on-one. They don't want it in an open room or anything like that, and the judge approved that. So that's kind of a peek of what will be looking like, or what it'll be looking like come trial. So it looks like that it looks like jury selection is going to begin a little bit before May 5th. Now, we all thought May 5th was going to be the date that it started. We all thought potentially opening statements could be on May 5th, but it looks like it's being pushed back a week, just because they're anticipating so many jurors to kind of come through that courthouse, whether or not to be selected for the upcoming trial. But it just seems that the defense kind of did get a win in pushing everything back just a little bit. But again, this is a big, high-profile case. They want to make sure all their ducks are in a row. They want to make sure they're dotting their I's, crossing their T's. And so while we can expect opening statements to be pushed back just a little bit, just about a week or so, what we can expect from those jurors is for them to kind of, again, 300 people every day up until they select the men and women who are going to be a part of that jury, but again, going to be sequestered while each side kind of gets to ask them these particular questions, and they're going to be filling out that jury or juror questionnaire, something that the government didn't necessarily want, but it seems like that's going to be the idea moving forward.
I mean, that's the hope. They have an idea about how long jury selection is going to be. This is a very high-profile case. There has been so much already put out there. It's not about trying to find a jury that doesn't know Sean Combs or knows that he's been criminally indicted. It's the idea of trying to put that away and put that to the side and go in objectively. Maybe easier said than done. We shall see. Elizabeth Milner, thank you so much for coming on. Thank you for being our eyes and our ears about what we're happening in that courtroom. And thank you for going down there. Really appreciate it.
Thanks, Jesse.
All right, so here's what we're going to do. We're going to wrap up, everybody. Thank you so much for tuning in. Thank you so much for your questions. We'll continue this maybe in the next pretrial conference at the end of next month. We shall see. Always developments in the Sean Combs case. We really appreciate your support. We really appreciate you tuning in. I'm Jesse Weber. We'll catch you next time.